My question is regarding an object clause stated in secondary purpose. Okay, so this is regarding the articles of incorporation of your company. Meron silang secondary purpose sa articles of incorporation which states that they can borrow or raise money necessary to meet the financial requirements of their businesses by the issuance of bonds, promissory notes, and so on. The question is there such a rule that requires the corporation to indicate the clause in article of incorporation? Or if we are to omit the object clause, will it mean that we can no longer borrow money? Meron po kasi tayong revised corporation code. Ito po yung pinaka-basic corporation law natin. And under the revised corporation code, nakasulat na po doon ang mga powers, no? Ang mga prerogatives ng isang corporation. So kung nakasulat na doon yung mga pwedeng gawin ng isang corporation, hindi na natin kailangang i-copy-paste doon sa ating articles of incorporation. Right now, based on my perception, ang direction po ngayon ng SEC, mag-concentrate na lang doon sa primary purpose, hindi na doon sa secondary purpose, no? Primary purpose na lang ang nire-require ng SEC ngayon for the registration of the corporation because all these other powers and the things that a corporation can do are already provided by law. Itong to borrow or raise money, this is something that all corporations can do. So you don't really have to state that. No, probably you should state that in your articles of incorporation to limit. But whether you state that or you don't state that, you can still resort to raising money, borrowing money, because all corporations are allowed to do that. Why? Because a corporation is an artificial being. It is parang tao ang isang corporation. May right yan to enter into a contract, to own properties, to hire people, to file a case in court, and also to be sued in court. So like any person, like you and me, mayroong legal rights ang isang corporation, and part of my right is to borrow money and to raise capital. A corporation, as an artificial legal entity, also have that right to borrow money and to raise capital for its purposes. It's not essential that you state that specifically in your articles of incorporation as part of your secondary purpose because that's a given. If you want to state that, wala naman po problema. Hindi rin naman po bawal. No? Pwede pong state yan. Maraming corporation that have been created prior to the revised corporation code. Bago lang po kasi yung revised corporation code. And they want to be very specific about it. They have a primary purpose and they have several secondary purpose and they want to state that, wala pong problema. No? Marami, yung mga old corporation, nakikita ko na itong to borrow money and to raise capital is part of their secondary purpose. Okay, so sino pa ang gusto before I go to the questions na naka-post dito? Baka may gusto